Hi friends, happy Monday. Here today to give you a little primer on corporate restructuring, business restructuring. I'm going to use the word corporation in this video very broadly because depending on your situation, it may make sense for you to be in a corporation, a limited liability company, a limited liability partnership, or even a business trust, any number of entity formations. But for our purposes, we're going to talk about a corporation just as any company with liability protection, and talk about reasons why you might want to restructure and how we might go about that. There are a couple of reasons I want to focus on, although there are many reasons why you might want to do it. One is asset protection, and another one is expansion of your business, and we'll talk about these ideas together. There's also other separate interests in that may develop within your company where there are a couple of different things you're doing, and you might find it more convenient and make more sense to have two separate companies doing those two different things rather than one company where you've got two different enterprises competing for resources and that sort of thing. But there are many reasons, but those are the ones I'm going to focus on today. Now, in terms of asset protection, having a corporation in the first place is fundamentally about that. It is allowing the owners of businesses not to be personally liable for the things that that might happen as a result of their doing business. And you can see as a policy matter why our society would adopt that kind of a rule. We want to encourage people to take risks, to form companies, to do things to increase commerce without worrying that they're going to lose all of their assets in the process of doing that because something goes wrong in the business. The business gets upside down or whatever. People are going to be a lot more risk averse in the market in the marketplace if they know that anything they do might result in them being personally liable. So we create a corporate shield that protects against individuals or other companies from being held liable for the actions of a particular business, a particular company. Reasons for doing this might include expansion. As I mentioned, you may have a situation, and I'm doing a restructuring right now for a company that they've got people who have invested and developed certain assets for the company, and as it turns out, they need to convert some debt into equity. They need to also organize things in a way that the people who have paid to develop the assets so far are not diluted to too great of a degree by the new investors they need to bring in to take the company to the next level. So you may form one company that holds the existing assets that the other company is going to need to continue to do business. And an example of that might be, I know I was part of a law firm at one time where two partners had gotten in and they had invested in a building. And they had that building bought and paid for by the time I was brought in as a partner, and other partners as well. And so a sensible thing to do in that situation is to put the building in a holding company, to let the law firm lease that building from the holding company, and then I could be a partner in revenue and other things, but I didn't gain an ownership interest in the building because that was already bought and paid for by the time I joined the business. And we can do that in a lot of different areas. Putting the building in its own holding company has asset protection value as well. It may, prevent the building from being used to pay a judgment in a lawsuit where the company has, has been sued, and you're looking for assets to use to pay the judgment. The building in another company, in another corporation is protected. So that's an important element. I've also done this for apartment rental companies, where you don't want to run the risk, say, of somebody falling down the stairs and being badly injured and having every unit in the entire company potentially on the hook for what happened as a result of one person living in one unit. And so you can separate out your separate units or separate buildings into separate companies to limit the liability of the entire enterprise for things that might occur as a result of things happening in one distinct unit. So liability protection is an important reason for creating corporate restructure. Another reason may be expansion of the business, which I mentioned before about the restructuring I'm doing right now, where the existing investors don't want their interest in what they've already developed diluted by the new investors that are being brought in, and so they're leasing those assets to a company where the new investors are going to own. Perfectly legitimate thing to do. So those are a couple of reasons why you may want to restructure and create new companies. One really important thing I want to emphasize is that you want to do all of this, your restructure, before a legal issue arises. If you do it while litigation is pending or after you've gotten demand letters from someone else, it's kind of too late. I don't want to say you can't do it then, but courts have a very dim view of that. If you did it sort of in an orderly process and it made sense, the courts will look at that very differently than if you did it while litigation is pending and it looks like you're trying to, let's quickly get the assets into a different company to defraud the creditors. So that's something that you want to consider, is you want to do this in an orderly process, not when you're about to be sued, where it looks like you may have just been doing it to hide assets or play a shell game with creditors, because that will cause the corporate veil to be pierced. A few other considerations with regard to asset protection and reorganization. If the management structure and the ownership structure of two businesses is very similar or even the same, that's another factor that will weigh in favor of piercing the corporate shield. Now, I'm not going to suggest that it's dispositive, but it is a factor the court will weigh. The more it looks like one business is the alter ego of the other or of a particular person, the more likely it is that the court is going to disregard that entity. Another factor is the commingling of assets. If the business, if I'm, say, going to the grocery store and and making personal purchases or whatever from my business account, that will weigh in favor of disregarding the corporate shield. Commingling of personal assets and business assets, or commingling the assets of two separate companies, will weigh in favor of piercing the corporate veil. Deliberate undercapitalization of a particular company will also be considered. If it looks to the court like you put all the assets in one company and all the liability in another one, took on all the debt in one company and put all the assets in another one, that's going to look to the court like it's not always dispositive, but deliberate undercapitalization looks maybe like you're trying to avoid some creditors rather than merely to limit liability. And so that's an important factor. Separate bank accounts, separate accounting records, and other formalities like that will help to avoid having your corporate veil pierced if you maintain those formalities. Maintaining other corporate formalities like separate stock and membership ledgers, holding your annual meetings, making sure you maintain an active registration with the state, informing people at the outset that they are dealing with a corporation or an LLC or whatever will weigh in your favor. And knowing which entity they're dealing with at the outset is important. Now, one objection I've gotten from a variety of clients when we've talked about restructuring is that it creates an accounting nightmare because you got to keep a separate set of books for each company. There are some ways around this, and whenever I do this, I work with your accountant to figure out how to not make this too cumbersome. But you're going to weigh the extra headache of keeping separate sets of books against the level of liability protection you need, and we're going to make a rational business decision of whether it's worth it to you to keep separate accounting records. But separate accounting records, separate bank accounts, and all that are factors that will weigh in whether a corporate veil is going to be pierced or not. So those are a few important considerations for why you might restructure and what some of the requirements might be if you're going to use corporate form or an LLC form, a limited liability partnership form, any of those for liability protection. And I hope that's been informative and hasn't been too much too fast. I've seen this really be helpful. As a litigator, I've litigated a number of these cases, and I've seen that corporate form, when properly maintained, really save somebody's business. And I've also seen situations where it's been done improperly and much to the detriment of people's businesses. So restructuring is an important tool in the toolbox of a business lawyer. If you would like to talk to someone about this, I'm happy to spend 15-20 minutes and just talk about whether it might make sense to you. My office number is 801-960-4559. You're welcome to call, or you can just private message me on Facebook, LinkedIn, whatever, and I'd be happy to talk with you. But hope this has been helpful one way or the other, and would be happy to come back and talk to you another time.